You are watching PR English Shorthand Dictations YouTube channel.
This is English Shorthand Dictation number 338 and the dictation speed is 100 words per minute. Ready? Start. We have heard the counsel for the parties and perused the materials on record. At the outset, we reject the contention of the respondent that the High Court, based on concession of counsel for the authorized officer, proceeded to pass the order for refund. After referring to the applicable statutory provisions, the said council submitted before the court that the interest of the authorized officer should be taken care of. Such a submission does not, in our considered view, amount to any concession, rendering the appeal not maintainable. Two legal questions now arise for consideration. The first question is whether the power of forfeiture was exercised by the authorized officer in an arbitrary manner. The second question is whether the High Court was justified in its interference with the forfeiture order on the grounds assigned in the impugned judgment and order. Sale of a secured asset, which is an immovable property, is regulated by Rule 9 of the Security Interest Enforcement Rules 2002. Bare perusal of the aforesaid provisions reveals an ordainment in Sub Rule 4 that, on mutual agreement, the time for making deposit of the balance amount of sale price can be extended for a period not exceeding 90 days, but extension beyond 90 days is not permissible on any count. Grant of extension for intermittent periods so that the duration of such periods taken together does not exceed 90 days would suggest some element of discretion being reserved up to the authorized officer of a secured creditor under sub rule 5 of rule 9. However, there can be no gainsaying that such discretion has to be exercised reasonably and not on whims or caprice. At the same time, no auction purchaser can claim extension as a matter of right, and that too beyond the statutorily prescribed period. Whether or not a case for extension does exist would depend upon the peculiar facts of each case, and no straitjacket formula can ever be laid down. If, however, circumstances are shown to exist where a bidder is faced with such a grave disability that he has no other option but to seek extension of time on genuine grounds so as not to exceed the stipulated period of 90 days, and the prayer is rejected without due consideration of all facts and circumstances, refusal of the prayer for extension could afford a ground for a judicial review of the decision making process on valid grounds. Sub Rule 5 of Rule 9 does envisage forfeiture should there be a default in payment of the balance amount of purchase price within the period mentioned in Sub Rule 4. The power of forfeiture is therefore statutorily conferred. Before we take our discussion forward, it is necessary to ascertain the true character of the term forfeiture. Black's Law Dictionary, inter alia, explains for feature as the loss of a right, privilege, or property because of a crime, breach of obligation, or neglect of duty, or something lost or confiscated by this process or penalty. It is also explained as a destruction or deprivation of some estate or right because of the failure to perform some obligation or condition contained in a contract. It is also found from the same dictionary that though penalty is usually referable to a crime, penalty is sometimes imposed for civil wrongs, such as a statutory penalty for a statutory violation, especially a penalty imposing automatic liability on a wrongdoer for violation of the terms of a statute without reference to any actual damage suffered. Having regard to the terms of Rule 9, the notice for auction constitutes the invitation to offer. The bids submitted by the bidders constitute the offer, and upon confirmation of sale in favor of the highest bidder under sub Rule 2 of Rule 9, the contract comes into existence. Once the contract comes into existence, the bidder is bound to honor the terms of the statute under which the auction is conducted and suffers consequences for breach, if any, as stipulated. The sub rule 5 of Rule 9 legislatively lays down a penal consequence. Forfeiture referred to in sub rule 5 of Rule 9 has to be construed as denoting a penalty that the defaulting bidder must suffer should he fail to make payment of the entire sale price within the period allowed to him by the authorized officer of a secured creditor. Though it is true that the power conferred by sub rule 5 of Rule 9 of the rules ought not to be exercised indiscriminately without having due regard to all relevant facts and circumstances, yet the said sub rule ought not be read in a manner so as to render its existence only on paper. Drawing from our experience on the bench, it can safely be observed that in many a case, the borrowers seeking to frustrate auction sales use their own henchmen as intending purchasers to participate in the auction, but thereafter they do not choose to carry forward the transactions, citing issues which are hardly tenable. This leads to auctions being aborted and issuance of fresh notices. The repetition of such a process of participation and withdrawal for a couple of times or more has the undesirable effect of rigging of the valuation of the immovable property. In such cases, the only perceivable loss suffered by a secured creditor would seem to be the extent of expenses incurred by it in putting up the immovable property for sale. However, what does generally escape notice in the process is that it is the malicious borrower who steals a march over the secured creditor by managing to have a highly valuable property purchased by one of its henchmen for a song, thus getting such property freed from the clutches of mortgage and by diluting the security cover which the security creditor had for its loan exposure. Bearing in mind such stark reality, sub rule 5 of rule 9 cannot but be interpreted pragmatically to serve twin purposes. First, to facilitate due enforcement of security interest by the secured creditor, and second, to prohibit wrongdoers from being benefited by a liberal construction thereof.